It's actually at 10 o'clock. Matt Spahn, he's going to present on estate planning and guardianship, and he does something that's near and dear to my heart. He's on the board with the Alzheimer's Association. So we can give him a warm welcome and get started. Thank you.
I sound like the claps, the applause at the golf tournament last week. Well, is this thing on really? Okay. It doesn't give a lot of feedback. So I was checking my mail yesterday, and I saw an envelope from a client, and I thought, oh, good, a check. And there was a check in it, a small check. And then this little joke book, 101 of the world's funniest one-liners. And I'm going to read them all for you. No. I'm going to read number one, the very first one. And I won't do a lot of statistics. Dr. Horton and the docs that you're going to see all week, of course, are going to be doing all that. And they're going to talk about blood, and that makes me really queasy. So, but I'll give you this statistic. It says, number one, 99% of lawyers give the rest a bad name. So why are y'all going to learn about legal issues on this week-long study of medical issues and aging? Well, because they do combine, as you know. And a few months ago, I had the pleasure to work with Jennifer on a one-day seminar called Medico-Legal Issues and Aging. It may have been more than one day, but it was just a couple days at most. And so we presented, it was usually like a doctor, then a lawyer, then a doctor, then a lawyer. And it wasn't that popular, I suppose, but we enjoyed it. So I'm going to talk to you a little bit about what Dr. Horton did too, though, about preventive practicing. Because guardianships is something we would like to prevent. We don't really want to get to guardianship. So you're going to keep that in mind as we talk about what is estate planning, and then we're going to talk about guardianships. But one thing I want you to know is we don't really want to have to go through guardianship. It's a painful process that can be avoided. So with that, what is estate planning? Well, you know, lawyers got to try to use these $5 phrases to sound smart. An estate is not a big house on a hill. It is everything that you own. And I always remind my clients about this part right here, life insurance and annuities too. You're 35 years old. For $35 a month, you've got $1 million in life insurance. Or maybe your employer provides it for you at a little bit of extra cost, and you thought, well, I need some of that. I've got a big family, and I'm an economic engine around here. Guess what? What they call the face value, which we would call the death benefits, $1 million, that's part of your estate, okay? So you don't have to be what we think of as a wealthy person to actually have a large estate, because life insurance, the death benefit, is part of the estate. Now we're going to talk about different kinds of assets, because that's a non-probate asset usually. But remember, it's part of your estate. The annuities, the 401ks, the checking or savings account, the brokerage accounts that you may have even joint tenancy with a right or survivorship, right? Two people on the account together. Still the first one who passes away, that's part of their estate. So it all gets counted up. I've never, ever had clients go through my, it takes us 10, maybe 15 minutes to go through all their assets, really. I've never had any set of clients not be totally surprised at the size of their estate. We think our estate is balanced in our checkbook, and none of us keep much of a balance there. If we have a lot of money, we know someone's told us don't keep much there. If we don't have much money, well, there's not much money. But it's not. We've got to remember everything that we own is part of our estate. What's planning? Well, we all know a method for achieving an end, a mental formulation, an achieved order. So what we do in estate planning is actually create a lot of different documents. And we're going to talk about those after this slide. But let's get some vocabulary down first. Let's talk about property in Texas. A lot of federal law that you're familiar with. And then, of course, a lot of things are state by state specific. And the states all have a different set of laws when it comes to estate planning, when it comes to wills and the powers of attorneys and all those things. Those are state by state. I've got some good news for you. First, I guess the bad news. Texas can mess up a lot of stuff. In Austin, that legislature that meets only a few months every 2 years, thank goodness they don't meet more than that. We had all these special sessions, and that didn't turn out maybe so good. We'll see. But we do lead the nation when it comes to a lot of these issues we're going to talk about. We're the easiest state in the union to probate a will in. We are leaders, definitely. The rest of the country looks at what we do in our living wills, our directive to physicians. They look at what we do in our medical powers of attorney. So we really have some great leadership and great legislation on those issues. Let's talk about property for just a second. Real property and personal property. Real property, not real estate. That's not what we call it. We talk about real property and we talk about personal property as the two most basic distinctions. Well, the good news is real property is real estate. When we're talking about real property, we're talking about land and improvements thereupon that you don't just move off, okay? Land and buildings, your house, this building, this is real estate, okay? What is personal property then? Any guesses?
Everything in it.
Everything else. Yeah, everything in it, okay? Yes, and everything else. Thank you. So, our bank account, our brokerage account, our 401k, our IRA, our life insurance, our business interests, everything in our house, all the junk in our car, right? Everything except real estate is personal property. So we know that distinction now. Let's talk about separate and community for a second. How many folks are married? Okay, I don't know if it's congratulations or condolences sometimes, but in any case, you know that in Texas, there's a presumption, and that's a legal term here. I'm not talking about the normal presumption. I'm talking about the state of Texas presumes once you're married that everything is part of the community. I had a client ask me this the other day, what the heck does that mean, community? I'm just married to one woman. No, the community property is you and your wife's property. So once you're married, if you're in probate, that proceeding we're going to talk about more, if you're in a divorce, the court is going to say we presume everything's owned together as community. That's kind of like being a joint tenant, right? That means everything's owned together and it's indivisible unless we have to divide it. So it's this interest in property that you can't really divide half and half, but you may have to someday. So that's what the presumption is. But realize this, until you get married, it's all your separate property, right? That's easy. But honestly, you can prove to the court, if you need to, that some things still are your separate property after you're married. What you bring into the marriage is really still your separate property. You bring a car into it, and it's paid for, title's in your name, that's easy, right? 10 years after you're married, you still have the car. That car is still your separate property, correct? Same thing with a house. But let's say you had $1,000 in your checking account, you got married, you opened up a different checking account, or maybe your spouse has started using your checks and putting money in there and got both your names on the account. Later on, you're getting divorced and you're saying, well, we got to split the community property half and half, but this is my separate property, $1,000. What's the court going to say? No, you've commingled it, right? We use that term, commingling. If we can't really distinguish the asset, if you've commingled it, you're not going to get to try to prove it up that it's your separate property. All right? Interesting thing about separate property, what you bring in, okay, that makes sense, right? But once you get married, are you married?
Yes.
Okay, if I give you this pen, make sure you give it back. Is that now community property? I'm giving it to you and your husband even. Is that community property? How many say yes? Oh. Don't be scared. How many say no? I'm not grading you. I'm not a real teacher. Okay. Taking it back. No, it's not. In fact, you can't make a gift to the community. Even if I tried to give it to her and her husband, they'd actually own it kind of half and half. A gift that you get once you get married, that's still your separate property, okay? And if they give it to you while they're alive, like I gave this gift, or if it was given to you through a will, through probate, or through a trust, that is still your separate property, okay? So your mom or dad passes away, you're married, they give you something in their will, before they go they give you something, that's actually your separate property. It's very important when it comes to some of the details later, okay?
What if you put it in a joint account?
Put the gift, commingle it enough, you're not going to be able to prove it later, are you? Even though it really technically is still your separate property, courts, you're probably not going to be able to carry your burden of proof in court, right? So the court's going to go, nah, you commingled it too much. It's community property. Now, interestingly enough, I mean, we've got some doctors, and I know all you guys are healthcare professionals, and some of you might not like attorneys too much. I can assure you I don't practice in personal injury. But we know that damages from those cases are what? Let's say you're married, and there's a malpractice case that you filed suit on, and you receive damages. Are those going to be community property or separate property? Maybe say separate. Right hand, let me say community, left hand. Well, you know, I'm a lawyer. I say it depends. Clients hate it when you say that, don't they? But it does. If it is for lost wages, that's community property. If it's for the pain and suffering, et cetera, that is your separate property. Clear? Clear as mud? Okay. Everyone understands separate and community? Question, go ahead. No, this is state by state specific. In fact, only 11 states have the community property rules similar to Texas.
I mean, if you live in Texas but you were married in
Oh no, once you get here, you're pretty much done. Yeah, we take you whether you want us or not. Okay, let's talk about property as probate and non-probate. And we're going to get into that in more detail too. But for now, I want you to realize that when you have a will and you pass away and your loved ones take it to an attorney and she takes it down, he takes it down to the courthouse to do that process of clearing title and all that is probate, those assets controlled by the will of probate assets. Like the house, right? Perhaps the car, perhaps your personal items, items of sentimental value, right? But what about the life insurance or the 401k when you've named a beneficiary? You've named your spouse, you've named your kids. Is that a probate asset? Is that an asset that the will's going to control? No. That's one of the most important things I can stress to my clients and to you here today. I have clients come in all the time that have 3 kids and the oldest is, just going to be the big helper. And so they're on all the accounts with them as a joint tenant with right of survivorship. They're named first beneficiary of the life insurance and the retirement accounts and all that stuff. But the will says everything goes to all 3 kids equally. So what do they think? They think that everything's going to, no. The house is, but the life insurance is going to the oldest, the retirement accounts are going to the oldest, et cetera, et cetera, et cetera. You must reconcile these non-probate assets, which is in fact much larger part of our estate than our probate usually, with the probate assets. We must reconcile those. So that's usually a big eye-opening thing. Good news is it's easy to fix. You get a beneficiary form from the life insurance company, from your retirement company, and you put all 3 on there just like that. But you got to have it right. Now, some have been given the advice of on your life insurance or even on your retirement, you could name your estate. The estate of Jane Doe. Good idea? Who thinks that's a good idea? Let the will handle it. Is that a good idea? Y'all think this is a loaded question? Usually it's not a good idea. Why? Well, because you don't want to make a non-probate asset a probate asset. Probate can take some time, even in Texas. And we're going to talk about that a little bit more in just a second. So it's usually best if you're naming people, or you may be naming trusts as beneficiary, but not your estate. Don't usually want to make a non-probate asset a probate asset by naming that. There we go. All right, let's talk about wills for a second. And remember, we're doing all this in the sense of, why do we do this? Well, one of the reasons we do all this is to avoid guardianship. But wills, quickly, they distribute assets post-mortem. After you die, they take care of it. If you've ever heard of the administration of estate, that's just another term for the probate of a will. Okay, now, one thing I want you to know about probate, that process of getting an attorney, going to court, getting this will in front of the court. The courts in Texas will allow it to be done very independently, usually. But wills can be contested, and other things can happen. But usually 95, maybe even 98% of the time, it's usually quite easy. But who has to be satisfied before the kids or the loved ones, the spouse is going to get the assets? Creditors. Say again, IRS? Well, they're the #1 creditor, you're right. But creditors, and there's a list of that, of how they stand in line. So I always want my clients to know that probate is a bit like a bankruptcy, right? It is, okay, here's the assets. This estate, the person who passed away, their assets, they have assets and liabilities. We must satisfy the creditors before we can move on to distributing the assets. And usually this process takes at the least 6 months if it's a real probate. It can take a year, it can take 2 years, they can last a long time. But I do want to repeat that wills in Texas usually work very, very well. No problem. Remember, inside of a will, you're going to name fiduciaries. Like, I have that duty for my clients, the fiduciary duty. That's the highest duty that I can owe someone else. It's a duty of course, no self-dealing. I must focus on their best interest and their best interest only. If I've got mom and dad in there and they're in their 80s and they have the capacity to do what we need to do, but the kids are saying what we really want them to do is this, who do I represent? Mom and dad. I have a fiduciary duty to them. Well, we give that duty to others. We name executors. That's just the person responsible, for getting the lawyer and making sure the will is followed, okay? It's not a tough job. They don't need to have any special savvy in finance or legal issues, but it doesn't hurt if they do. It just needs to be a trusted person. That's the person responsible for the person who created the will to carry that through after they're gone. And then trustees. I always have a trust inside of a will. And I don't really have the time today to go into that in too much detail, but we'll talk a little bit more about that later. But also, for everyone who has minor children, or children who are, have capacity issues, who need guardians, even if they're adults of adult age, one of the best things you can do inside of a will is, of course, name guardians. If you don't, there will be a court battle, and the courts of Texas must decide what's in the best interest of the children, and they'll have to find the best guardian, okay? So you can save a lot of heartache and a lot of expense, right? Save a lot of money by having a nice little will that names guardians. Well, now, we're going to just leave that aside, okay? Because this is really about incapacity and guardianships and how to avoid that. So we're going to talk about what I do with my clients in a plan for incapacity, because I don't really have any clients that I can think of that I don't have a will on the one hand, and then about 5 documents for incapacity on the other. Sometimes 6, 7, 8. We can do a lot to avoid guardianship, and we try everything we can. So first is this statutory durable power of attorney. Anybody can tell me what that is? What are we talking about here? We're talking about medical issues here? No. No, we're talking about financial issues. In fact, my code for that is the financial power of attorney. I've even called it a business power of attorney. I bumped my head on the way out of here, and y'all have to put me in this hospital for 2 or 3 days. Bills still have to get paid, right? I may have some more clients' checks come in. They need to be endorsed and deposited, right? All kinds of things go on. Life goes on. Who is going to take care of my finances? Well, the person who I've given this statutory durable power of attorney to, right? Yes, ma'am.
Is that just being on the signature card, or is that more than that?
That's more than that. This is a document. A will is a document. This power of attorney, this financial power of attorney is a document that says, you don't have to be on the checking account. You don't have to even be anywhere, but I'm naming this person. And remember, we're talking about power of attorney in fact. An attorney in fact, another name for that is agent, right? I'm an attorney at law all the time. When I am retained, I become an attorney in fact for my clients. But you can be an agent or an attorney in fact for people too, if they name you there. This one says, basically, you can sign John Smith, POA, Jane Smith, on anything. File the taxes, endorse the checks, pay the bills. Life goes on. Very useful. Now here's one that you can use even if you're not incapacitated. I was out of state once for 3 weeks. We'd sold our house. Closing was while I was out of state. My wife signed Lori, and then she signed Lori POA Matt. And you know how it is to close the house, right? I like dealing with an attorney. But you sign your name a lot. Well, we closed on the house. Well, wasn't that convenient? What if I'd had an accident and was out of it and couldn't sign my name? What would she have had to have done to sell the house? She probably would have had to go to the courthouse and file for guardianship, right? So this thing is nice and handy, but it's also essential in an estate plan. Okay? Let's talk about the medical power of attorney, which may interest you all a little bit more. Y'all may know a lot about that. I explain things very simply to my clients, and to me this one's real simple. You give me medical power of attorney, I make all medical decisions for you when you can't make them, right? If you're incapacitated, right? Do not resuscitate decisions, life-sustaining treatment decisions? Yes. Decisions on this procedure, yeah, the little ones and the big ones, right? Medical power of attorney. Straightforward, simple. Now, I'm going to tell you something. On these documents, I'm usually getting my clients to name 3 people too. Not just one, not just the spouse. What if your spouse is out of it? What if he or she's unable or unwilling to serve? Death or incapacity. Who's next? Okay, what if she's unable? Who's next? We have a contingency plan that's almost foolproof. So there's always someone there to serve you. Directed to physicians. People call it a living will, right? People are talking about living wills, and they're talking about the will, the last will and testament. No, it's not that, right? Some people are talking about living wills, and they're really talking about living trust. That's not it. I wish that name would have never come up because it's so confusing. It is the directed to physicians, surrogates, family members, or surrogates, right? That's what we really call it in Texas. And I always tell my clients, isn't this nice to have because this controls that, all right? The directive takes authority from this power of attorney. It also takes a burden from that person, right? What is the directive? Everybody know what the directive is? Someone give me a shorthand version of it?
Whether or not you want life-sustaining.
It is. It's about life-sustaining treatment. Only, and only if you are terminally ill or irreversibly ill, right? So, life-sustaining treatment, ventilators, respirators, kidney dialysis, artificial nutrition and hydration, subcutaneous, in the vein, everywhere else, and all the meds and drugs that go with it, right? That's what our legislature said was life-sustaining treatment. Made it clear for us that it may mean other things in this classroom or somewhere else, but for us in the law, this is what they are. Okay, so that's life-sustaining treatment. What's a terminal illness by the legislation? Anybody tell me? A terminal illness? The doctor's statement says, if we give Matt all 5 of those, and anything else we can think of, he's still not going to live for 6 months. Now, what's the premise? And do I have capacity? Can I tell them if I want life-sustaining treatment or not? No, if I can tell them, they have to listen to me, right? This document, the medical power of attorney, the same way, does not come up unless I can't communicate. Or even if I can, I don't know what I'm saying, right? So this does not come up unless I'm incapacitated. Then they look at the document. Okay, Matt said this. He said, no doubt most people say they don't want it, okay? But it's your decision. If you want it, you say you want it. And you can even get more specific. Terminal illness, we know what that is. What's an irreversible illness? Well, my client's hereditary SHIBO. So that's an easy example to give them. But the doctor's statement, the physician's statement would say, if I give Matt, who's incapacitated by the way, 1 or more of these life-sustaining treatments, he will live more than 6 months. Like artificial nutrition and hydration. Now, I'm not going to get any better. I'm out of it. I'm not going to be able to care for myself. There's no cure. I'm not, this isn't going to get better. They can make me live for more than 6 months with 1 or more. Could be all 5, could be 1. But it has to be 1 or more, right? I can decide on the document, yes or no, if I want life-sustaining treatment. If I'm terminally ill, then yes or no, if I want life-sustaining treatment. If I'm irreversibly ill, could be 2 different decisions, right? Does that make sense? Is this important? Very important. Would we have ever hereditary SHIBO if she had one? Or even if she just had the medical power of attorney? Now, the Hipaa. Y'all know about Hipaa, right? Well, I've got a Hipaa release inside this document for my clients. Okay? But I do one separate, and that's more for this financial power of attorney. You ever call some benefits group about your spouse? The bank ever called for your, loved one, and you said, well, no, but I'm on that checking account too. Hold on. He opened the account. You can't find out anything. Well, in this world where everything is so private, this Hipaa release comes in very handy because you can't even do this stuff if you can't get the information. So we have a Hipaa release. The catch-all, and gets us into our big topic. The declaration of a guardian for you, not the kids. If these things fail, why do they fail? Well, banks, financial institutions, governmental agencies that may pay benefits, et cetera, sometimes get tired of these powers of attorney, don't they? Sometimes they get other family members in there who may have the same relational status as a person who has that power of agency. We got a sister and another sister, and she's saying do one thing, and the sister's saying another. And the doctors and the hospitals are going, we're getting our butts sued, either way. So what do? Well, let's start telling them to go get that guardianship. So sometimes they force us to go get a guardianship, which we're going to talk about more. But anyway, my clients, we can't do the guardianship now, would want to, would need to. But what we can is say who we want to be our guardian. right? I can say, I want my wife to be my guardian if I ever have to have one. And then if she can't do it, I want my brother or whoever, right? So then does that make the process easier if we have to go get a guardianship? Yeah, makes it easier. And that's what this stuff is about. Now, if you don't love anybody, estate planning is not interesting to you. But most of us love others. And we don't want them to suffer in our incapacity or in our death, right? We just want them to grieve for us or celebrate our lives. And so, we take care of them. Let's talk more about planning for incapacity. Some of my clients want to donate organs. Isn't that sweet? It is wonderful. Now, some say, I will not give my skin, and I will only give organs to my family members. Can you be that specific? Will that work? Yeah, right? You can be totally general, or you can be very, very specific, okay? So that's, as everything else, is a big-time personal decision. Declaration for mental health treatment, totally different document, but very important. Y'all heard that I do serve on the board for the Alzheimer's Association, the Star Chapter of Texas. I even had the pleasure of being in D.C. about 2 weeks ago for 6 days, learning all about the latest developments in science and cure and prevention, et cetera, and also going and lobbying there. And so I learned a little bit about medicine because of my practice and because of some of my interests on the side as a volunteer. But you know, I oftentimes tell people when we're talking about Alzheimer's, it's like a lot of other mental health things. And I'm old enough to remember when cancer was a 4-letter word and you didn't talk about it. Some of you guys know what I'm saying here. Now it's no big deal and we beat it all the time. But there was a time when you didn't even tell people. And mental health is still there, and Alzheimer's can still be there too, right? It's just somehow it's your fault or it's some mark upon your family if this happens. But if I have a client and I get to know them, which I like to, we talk about this document. Because you can say, I do not want this type of treatment. I do not want this type of drug. I do not want to be restrained in this way. I do want this, this, and this, okay? And so when I had a client 2 weeks ago who's bipolar, he knew exactly what he wanted to do in this document as we walked through it together. And it was important for him to have it. But again, not everyone does these. Donate bodies for medical study. I've actually had two sets of clients in the last 2 weeks that are donating their body over here to UT Health Science Center. Isn't that terrific? We do a form for that. Now, if you go back to this donor form, you remember we used to do it on the back of our driver's license? We don't anymore. We may say we are a donor, but they're going to be looking for the form, right? And there's different ways to do it, of course, but I do that form for my clients, and then we try to get it in as many places as possible so people would know. You can appoint, well, this is a terrible name, an agent to dispose of remains. I got to do something at the legislature. That is horrible. I hate to tell my clients that. It's like, there's one more we could talk about. Some of my clients, it's very important that they were cremated, and their spouse respects that, but their mom and dad, you know, if something happened, were totally free. So they want to have it in a document. Look, I really want to be cremated. You know, I had a client who wanted to be cremated, have her ashes mixed with that of her cat, and spread over Lake Canyon. So guess what? That's in her document. And we also named the person, and maybe 2 or 3 extra just in case, who will make sure that happens. Okay, we can do an out-of-hospital do not resuscitate too, right? And that's a very rare. But for those folks who are in that situation and want that, it's important. So now this thing we've been talking about trying to avoid. We talked about wills, right? We talked about property. We talked about all these documents. Each one of these is a separate document to help plan for our incapacity and set things up for our death even. But what's a guardianship? Well, the court orders a surrogate decision maker. We call that person an applicant, not a petitioner, but an applicant, right? You go down, you're the one filing for this in the court, in our probate court in Bexar County. You're doing this for the incapacitated or the proposed ward, right? Ward. Okay. So what's one of the first things we've got to have? Well, the position statement. An opinion of medical condition. And what should it say? Well, it should give the nature and degree of the incapacity. It should talk about a physical or mental condition making the proposed ward substantially unable, and here we go, it's kind of like, you know, activities of daily living. Provide food, clothing, shelter, care for their physical health, manage their own financial affairs. There's forms for this that physicians can utilize. They can do it all on their own. There's guidelines there, but That's the basics. That's where this starts. We've got to have someone who's incapacitated. I don't know if that's the term you guys use. That's the term we use in law to talk about someone who just can't make decisions for themselves. You know, I have got to, no matter, and I serve clients in their 20s, I serve clients all the way into their 90s. It doesn't matter their age. Every client that comes in, I have got to decide, do they have the capacity to do what we're contemplating here? Do they understand or will? And everyone's at a different level. None two of us are at the same level. So each client has to be judged, and it's part of my duty and part of my ethics to decide where they are and can they do this. So again, when we go down to the courthouse to get this guardianship, this court order, we've got to have this physician statement. There's going to be a medical prognosis estimating their incapacity. That's their inability to make these decisions. Okay. What are some of these issues that's going to be in the physician statement? Their ability to make or communicate responsible decisions. So not just decisions, but responsible ones. Those would be ones that would serve their best interest, right? Does their medication affect their ability in court? The court's going to want to know that. Describe condition of diagnosis of senility. Other information, of course. Then there is the suit and the notice. So, your mom is out of it. She didn't do the powers of attorney. You can't sign your name POA her name and take care of her financial affairs. There's confusion as to who's in line first to make medical decisions for her. There's no medical power of attorney. There's none of these other documents we talked about. You need to get a guardianship. Everyone says you got to get a guardianship. There's people looking for you to make decisions. So you're going to file suit in the court. And there's going to be notice sent out to the proposed ward and other family members and things of that nature. And you go through a list. There's going to be a court-appointed attorney ad litem. That's the first thing the judge basically is going to do, is going to make an attorney represent the proposed ward's best interest. Now, this attorney isn't just there to think about what's best for the client, but to represent the client. Even if the client may not know exactly what's in their best interest, that attorney has a more specific job than they used to. They've got to do what that client really directs them to. Yes, ma'am?
How long is that take? And is there someone in between? I mean,
There's a, and I'm, at the very end of this, there is a limited guardianship and there's a temporary guardianship, and so they can be done quickly if necessary. But this can take weeks, at least weeks. It can take months, but generally we're talking about weeks instead of months. Okay. Okay, the proposed ward will actually be at the hearing unless the court says no, not necessary. Now, again, real world, I guess 90% or so of these things are pretty cut and dry. The person is incapacitated. Everything comes back in and shows that. They won't show up at the court. The judge will feel very confident in what she's doing, and everything will go okay. But that's part of it. There is a court investigator. So we have an attorney ad litem representing the proposed ward's best interest and representing legally. And then there's a court investigator. Goes out, where's the client, where's the proposed ward, what's going on? Are they in a facility or are they at a home? And anyway, they make a really neutral report to the court. And that's kind of a newer thing, and that's very important. It's a good thing to have. Then the court, again, may grant complete or partial control to the guardian. Now, let's say you had powers of attorney over mom. And then your sister went down there and got this guardianship, and the court granted it and signed it. Who controls? Who says the guardian? Who says still the person with the power of attorney? Okay. No, it's going to be the guardian. The guardian is going to trump over. All those other documents basically will become null. The guardian is going to be making all the medical and financial decisions for the ward, unless it's limited somehow, okay? Which isn't very common, but it can be, okay? The temporary guardianship, again, is an intense, quick, and it's a limited thing. They don't want that, but they'll do it under emergency. Courts act under emergencies all the time, right? Temporary restraining orders, temporary injunctions. This is that kind of issue. Does this make sense to y'all? Y'all know what a guardianship is now? Court-ordered, invasion in a person's privacy, right? But yes, if that person is incapacitated for those reasons they are, the court will grant someone else surrogate decision-making ability. Okay. Got a question? I got 20 minutes. I'm looking at my clock. Yes, ma'am.
Yes, so if you have someone that has the power of attorney, but there's nothing guarding them, within the guardianship, they need to make that change and add it. Because otherwise, then someone's going to overrule the power of attorney if they're not.
Well, it could. Let's go through this one more time. While you have capacity, and while your loved ones do, what should they do? They should have a plan, right? They should have a will at least. They should have a financial power of attorney, medical power of attorney, probably do the directed to physicians so they can make that statement clear and take a burden from the person who has their medical power of attorney, take some authority from them. They should probably have a document, because it's only 2 pages, saying, look, if I ever have to have a guardianship because of whatever reason, if the bank's, get in a fuss, if the government gets in a fuss and people are insisting on a guardianship, here's who I want to be my guardianship if you have to go down there and do that. But if you do all that, there's a good chance that you won't have to have a guardianship. But if you did, somebody, and it's probably going to be the person who's there and closest and who has been named already, would go down to the court, file the suit, go through this process, be granted guardianship. So the same person who actually was named as POA is going to probably be the guardian. I say probably because that's not always the case. Guardianships actually end up being quite litigious. Our wills are seldom contested. Usually that goes quite smoothly. Well, usually people leave everything to their spouse. If their spouse predeceases them, it all goes to the kids equally, right? So there's very little need to fuss about things. The kids can fuss with each other about how to split it, but they're not going to go into the court and say, I deserve more than my third. But guardianships become litigious. And you can see bad characters in guardianships, right? They're looking for the license to steal. But you see people with powers of attorney who've done that. And, again, it's like, this is notarized and witnessed, but we don't know the capacity of that person necessarily when they sign this power of attorney. And you're not, you're the half sister, not the sister that caring for her. And, things go on. So questions arise, and thus creating the need for the guardianship. But you do want to avoid the guardianship if at all possible, and the best way to do it is with a plan. And there's one other step, and I want to go through that and definitely leave the last 10 minutes or so for more questions. But ask a question anytime you have one. But I want to talk about trust for just a second, because I mentioned it earlier. When you form a corporation, just like UT Health Science Center is, right? It's a nonprofit, but it's a corporation, right? You just write some words on a piece of paper, right? You file that with some people. Next thing you know, you're starting to do accounting under that name. You got bank accounts under that name, et cetera, et cetera. Poof, you've got this legal entity. Well, in the law, we actually call a corporation a legal person, not just a legal entity. I want to let you know that if you think a trust is a department at the bank, well, no, those are trust officers, okay? A trust is simply a document wherein you state your wishes, okay, about assets. So by writing words on a piece of paper, you create a trust. And think of it as just an entity that holds assets to benefit someone else, because that's all it is. The first one was created in the year 66 of our Lord by the Roman emperor. He wanted an entity, a legal person, that would hold assets to benefit someone else, hold it in trust for someone else. Okay, so we've got a trust, and we know those are words on a document that create this legal person. We know it benefits someone else. Could it benefit a lot of people? Yeah. It could benefit a community even, right? But at least one person or more. And so those are beneficiaries. Trust beneficiaries. Well, who are the people or the person that's going to manage the trust? What's that person called? Trustee. So it's kind of 3 parts I think about. You got a trustee, you got a trust, you got the beneficiaries, right? Now some people say, and I hear them on different mediums saying, trust is just a contract. And that means, of course, it's just like written on a piece of paper. It's a contract, but it's a little bit more because we create a person. Just like an individual is a legal person, and a corporation is a legal person, and a trust. So a trust, though, remember, a corporation's supposed to do something. It's supposed to do some kind of business, whether it's profit or non-profit, right? But a trust is supposed to hold assets to benefit someone else. So, testamentary trust, the last will and testament. So, when the couple comes to me and they have no kids, and I tell them about the trust that I want to put in their will. Trust for who? Well, he's 90 when he finally dies, and you're 88. He's going to leave you a few years of peace. You're going to look so much better. You don't have to take care of him. What what about if you're incapacitated at that time? I mean, all his assets are going to you, but you can't manage them. In fact, you haven't been managing them for 8 years because you have some kind of dementia. We saw that she was incapacitated, and we needed to put the assets in a trust. We have a trustee already named in the will and a way to choose others, all those contingencies planned out, but the assets could go into a trust to take care of her. That makes sense? Now, if we've got kids and they're minors, can they really own property? Not really. There's a lot of quasi-ownership, but it's not real ownership. Can they manage property? Come on. No. At 18? No. Maybe not at 28. So we definitely talk about the need for the trust for the kids, right? So all we're doing is putting a couple little paragraphs in the will that says, if my children are under the age of 25 or 18 or 50, doesn't matter, you choose, then the assets go to them, but goes to them in trust, right? That means so-and-so is going to be the trustee. They'll be the beneficiary. Here's a wild one. Let's say we want the kid to be the beneficiary, right? Could the kid be the trustee? Who says no? Okay, we've got a couple of brave people that will raise their hand. Who says yes? No brave people. No, we have 2 more brave people. 4 brave people. Actually, yes. Okay? You can be the trustee and the beneficiary of the trust. Why is that smart? Why do I have that plan for myself? Well, do you think I want my daughter's divorcing husband to take my assets? No. When I go, I want my daughter to have my assets, and I want them to be her safety net, and I want it to go into my grandkids and maybe my great-grandkids. If I leave them to her, they're subject to her creditors, her bad luck, her divorcing husband. The list goes on and on. Bankruptcies, all that. If I leave it to her in trust, and when I say she's 30 or 35, she can be her own trustee, does that protect the assets? If there's anything you need to know about a trust, when you give assets to someone else in trust, if you do it honestly and ethically, of course, not trying to avoid something, you don't do it with fraud, it truly protects it for generations, okay? You know names like Vanderbilt and Rockefeller, not because they created so much wealth, but they've protected it over generations. So know that we have good wills, have trusts inside of them. They don't always get created, but if they're needed to be created for minors or for others, they're there, okay? Then there's this thing called Revocable Living Trust. Who's heard of the Living Trust? Okay, you same people are confused about living trust, probably. No, you might know it perfectly. I'm kidding. But there is a lot of confusion over them. I'm going to just take you through this real quickly because we're about 12 minutes still. Living trust versus wills. Okay, if you want to have your assets in a trust right now, be your own trustee and your own beneficiary, you can do that, okay? You just retitle the house, you retitle the car, you retitle the bank accounts, it's all in the Smith Revocable Trust, right? Does that protect your assets from creditors? No. You didn't give it away to somebody else, it's still in your name. Tax-wise, nothing changes either, it's just kind of a pass-through entity. But you can send your assets to your kids without going through that probate process. Now there's 2 camps. There's those who are out there selling living trust. You got to have a living trust. Are you crazy? You can't go through probate. Probate's horrible. You got to have a living trust. I don't fall into that camp, right? Probate's not a problem in Texas, usually. There's also those who say, oh no, you got to have a will. Don't go through probate. You can't have a living trust. It's horrible. It's horrible. I don't fall into that camp. Those people usually don't understand trusts, and so they're a little bit afraid of it. Okay? If my clients, when I go through with them and they have land in other states or other countries, if they're not going to leave everything equally to their children, if they own a business, those are all big red flags for me to discuss with them in detail how a living trust could really benefit them, okay? Because a living trust, you wouldn't have to worry about the contesting of the will. You can handle the property in other states without having to go through probate over there, et cetera, et cetera. I'm not going to go into more detail with that, except to say, here's another way to avoid the guardianship. If I have a living trust, and I've got myself and my wife as trustees and beneficiaries, and then I've got my best friend and a CPA named as successor trustees, and I'm incapacitated, so then my wife is managing all the assets. She's not even using the power of attorney, is she? The financial power of attorney, right? Let's say she becomes incapacitated or she dies. We have a successor trustee. these bank accounts and all this stuff is in the name of the trust, right? They look at the trust document, the financial institutions, and go, well, okay, I've got evidence. The next person takes over, that's, Matt's best friend. Does that make sense? So sometimes, well, oftentimes, the living trust can help to avoid the guardianship. And that's why I kind of saved it for last. Trusts are a bit more complicated, but they're a bit more powerful in what they do. They will do everything a will does. They will send your assets where you want them after you're gone, right? But they will also manage your assets while you're alive. So if you're incapacitated, someone else can become the trustee, and yet you're still the beneficiary. I'm just going to real quickly tell you there are things called irrevocable trust, trust you cannot revoke. They come in different forms. And this institution, UT Health Science Center certainly uses things like that. Philanthropic minded folks leave gifts through irrevocable trust. So just know basically what that is. Now, you're married. Both of you are carrying $1 million of life insurance because somebody really good got to you and said, for $35 a month I can get you into this term life insurance. Or you did it online. And it said, have 10 times your annual salary or something like that. So you've got $2 million to both of you, right? Because of the death benefit on your life insurance. You got your 401ks with a little bit, you got this with a little bit, you got the house that, well, it's increasing in value 14% a year here in San Antonio, so you've got assets there. You actually are a very middle class person, and yet you've got more than $2 million. Now they call it the estate tax, and they failed to repeal it week before last, when the Senate was unable to reconcile with the House. I just want you to know that if you die, or when you do, and you leave it to your kids, there's the death tax. You've heard of it, the estate tax. You get taxed when you buy gas, when you buy milk, for your income, when you sell, something. I mean, there's taxes everywhere. There's even a tax when you die. If you don't do the right planning. With right planning, you can avoid it, you can postpone it, you can defer it. The gift tax is actually still at the old amount of $1 million. And how it affects the estate tax, well, if you try to give things like away while you're alive, the limit is $1 million instead of the $2 million. So just know there is a gift tax. There's also a generation skipping transfer tax, but we won't go into that in great detail. There are things that you have to do to pay those taxes, but there is a spousal exemption. Bill can give Melinda the $42 billion, right? The Gates. He could leave it to her in his will. There would be no estate or gift tax on it. But when she goes to give it to the kids, whammy. So all they've done is defer the tax. But there is the charitable deduction, okay? Leave it all to a charity, which they're doing, the Gates Family Foundation. No estate tax. No gift tax, right? And yes, I do have a few clients that I've helped them create their own family foundations, and they do great things. So there's a little bypass trust a lot of my married clients use. I won't go into that. Save time for more questions. I think we ought to call estate planning life planning. We call it estate planning, but it really ought to be called life planning because it's about your assets afterwards, but it's about your incapacity anytime. So remember, you've got to align your probate assets like what? What is probate assets? Things absolutely controlled by your will. Your house, perhaps your car, perhaps those personal items. What's an example of a non-probate asset? Right. Life insurance. But if you named your estate as the primary beneficiary of your life insurance, then it became a probate asset. And you probably don't want to do that. There's exceptions to it, but you ought to get legal counsel on those things. And trust assets are things you put in a trust. So 3 different things pass 3 different ways. Passes by the will, passes to the beneficiary named or the joint tenant with right of survivorship. Does anyone have a question about JTWROS, joint tenancy with right of survivorship? Y'all know what that is? Right? When you do your checking account, your brokerage account, your savings account, they ask you how do you want to title this. If you're married or if you have a significant other, they could be just a co-signer, right? It means they could sign the check, but they don't own the account with you. But if you do it as a joint tenant, then you both own it. If you add those words with rights of survivorship, when you go, those assets become theirs. That's a non-probate asset. Doesn't have to go through the will, right? Very nice, very handy. Now, all those assets are considered in your estate. But this is another part of life planning, is to do as many things that we want to do, JTWROS, as we can. So, of course, when I'm working with my clients, we're usually looking at every account, making sure we know exactly how it's titled, how the beneficiaries. Anyone heard of POD on a banking account? Payable on death. That person doesn't own the account with you. Probably can't sign on the check for you or with you, right? But when you go, what's going to happen to it? It goes straight to them. Is that non-probate asset? Yes. So that's usually a good thing, right? Okay. Probably my last slide. I have only about 6 minutes left. Questions? Yes, ma'am.
The living trust, would that protect property from that Medicare thing that's going on now where they can take your property? Is there anything that can protect?
The living trust, the revocable living trust, really won't protect an asset. You're probably talking about Medicaid applicability.
Medicaid? Okay.
So for 1 second, and I know some of you know more about it than I do, I'm sure. Medicare is that life insurance program that every one of us gets when we're 65. We might get it earlier, but basically when you hit 65, we have a health insurance program for you, okay? It pays for a lot of your co-payments and doctor visits and all that stuff. And you can supplement it, right? Part B or Part D and all that. Medicaid and Medicare, by the way, is a federal program. Federal program. Medicaid, similar name, another big mistake, because it's a totally different program. Medicaid is administered state by state. Our legislature changes our Medicaid rules every time they meet, okay? Which is okay, but they do, just when we get used to what the rules are. Anyway, now federal funds do come into it, but we also put some funds in it ourselves. Medicaid is a program for the indigent, okay? Now, do most Medicaid monies go to the elderly? Yes. Okay, Medicare is paying for your doctor's visits, your clinical things. You go into the hospital for 3 days, they say, we'll release you to a skilled nursing facility. Medicare can pay up to the first 100 days, right? They do 20 and they may do a little bit more. But that's it. That's the insurance paying. If you're going to need to be in long-term care extendedly, whether at home or in a facility, Medicaid might pay for your stuff if you're impoverished. If you have assets or income, you will not be getting Medicaid. Spend them down, Medicaid will start paying. You can protect some of your assets. It's very tricky. And people get in trouble for this too because they cross the line sometimes. One thing you've got to know before I leave, did I give anyone here legal or tax advice? Go like this. No, Matt didn't do that. Are any of you my clients? No. Now, I don't have to charge you money to be my client, but unless you're my client, I can't give you legal or tax advice. No CPA and no attorney can, so never be confused by that. That means I can't tell you what you should do. What I've shared with you today are basics, okay? I've tried to give you some good vocabulary and given you the outline, the blueprint of this process of planning for incapacity so that you can avoid getting a guardianship. And if you had to get a guardianship, I showed you the outline of the process. In most of these things, you're not going to do this without the right attorney. There's good attorneys in this town. They're in the yellow pages. They're in other places. Most people get an attorney by asking, you know, San Antonio is a got-a-guy kind of town, right? You just ask them, oh, I got a guy that does that. And that's how all my clients come to me, because you actually won't find me advertised anywhere. So, but there's plenty of good attorneys out there that do guardianships and they do wills and powers of attorneys and things like that. Now there's more questions. Yes, ma'am.
When you were talking about creating a guardianship, you said that a physician would make a statement of an opinion of medical condition.
Yes.
Are there any other providers that can do that other than a physician?
We're looking for a physician statement. Now you can supplement the evidence with others, but we're going to have a physician's statement. Could be a psychiatrist, but again, must be a physician. Could be the internist, could be the family practitioner. Other questions? Yes, sir.
Can a guardian force the ward to get medication?
Well, yeah. You know, they said President Truman wanted to have a one-armed economist because they were so much like lawyers. They were always on the one hand, da-da-da-da, on the other hand, da-da-da. Your question is one of those that is a gray area. They can certainly, I mean, that's in the real world, you know, when someone's refusing medication, the guardian can't really force them. We can't really do that, but that doesn't mean there's not other things done in the medical community to ensure that person gets the medication that they need. I mean, clearly if the person has had a full-blown guardianship, someone was their guardian, and somehow yet they were still refusing some medication, well, if they didn't have the capacity to truly understand the refusal, then I think you're going to find that they're going to be getting that medication. Because the guardian's going to be able to decide, no, we'll take the medication. But if they're competently or with capacity refusing it, that's a different issue. These things don't go easy, right? I mean, medicine doesn't. What little bit I know about medicine, I mean, it's all kind of like, well, we got a 60% chance of this and a 40% chance of that. The law's not much different. I mean, sometimes we get down there and the person has this, directed to a physician saying no life-sustaining treatment, but every single family member is saying hook them up, right? And the doctors are caught in a quandary. The hospital's in a bad place. The law says, really, the directive is supposed to control it. But they know what's going to happen if they don't follow every single family member's wish right there. So it becomes tough, and you get into little committees, and you get into little, think tanks, and you start talking about what's the best thing. But it's always, or should always be, a focus on the patient. And I'm out of time, so I want to thank y'all very much for your attention. And